This is our final case of the case call. It's a 15-minute mini oral argument on the application. Mr. Doman, you will reserve time if you want to, but we'd like you to keep track of that. Doesn't always work out. Good luck. And you may proceed if you're ready.
Thank you. Good afternoon, Your Honors. May it please the court, Tim Doman on behalf of Cleophas Brown. I'd like to just give some brief commentary and then I can pause for questions. So to resolve the first issue the court has asked us to address, and that's whether notice is required under the statutes. There are basically two steps we're asking the court to take analytically. So we start at the CCW statute, which is what our client is charged under. And that statute explicitly says that it does not apply to a person who has a license to carry the pistol as provided by law. And so the question becomes, what does as provided by law mean? The prosecutor argues that the phrase merely distinguishes governmental licenses from private licenses, but respectfully, I don't see that as a natural reading of that language. Instead, under the case law referenced in the reply brief, as provided by law contemplates that the legislature will provide a framework for people to be licensed to carry concealed pistols. And that's exactly what they did in the Firearms Act. And so that's the first step we're asking the court to take, to recognize that as provided by law in the CCW statute gets us to the Firearms Act. And once we get to the Firearms Act, we hit 428 subsection 8, which says that when an order is entered, either suspending or revoking a CPL, the CPL holder is not criminally liable for violating the order unless he has received notice. And so the second step we're asking the court to take is to hold that for a suspended or revoked CPL holder, prosecuting them for CCW is subjecting them to criminal liability for violating the order. Now, the prosecutor says that in this situation, you're prosecuting the CPL holder for violating the CCW statute, not the order of suspension or revocation. And so 428 subsection 8 doesn't apply. But I don't know why those need to be mutually exclusive concepts. To me, in this type of situation, yes, the person is being prosecuted under the CCW statute, but the factual basis for that prosecution is carrying a concealed pistol in violation of the order of suspension or revocation. By analogy, think about a driver's license suspension. When your license is suspended, the Secretary of State issues an order to that effect. And if you violate that order, you can be criminally prosecuted under the Motor Vehicle Code. So in that instance, you're being criminally prosecuted because you violated the order. And it's the same situation here. When you receive an order of suspension or revocation, it basically says, number one, you can't carry a concealed pistol anymore. And number two, you need to send us back your license. And so if a CPL holder ignores that, they're violating the order, which then exposes them to liability for CCW. So they're two sides of the same coin. Now, turning to the facts of this case, I recognize that this is not the cleanest fact pattern in the world, but I think the court needs to recognize.
Let me interrupt you here before we get to the facts, because I think we want to focus a little bit just on the way the statutes interact, because that's the reason why we took the case. So let me see what questions people have. Justice Clement.
No questions right now. Thank you.
Justice Kavanaugh.
No questions for me.
Justice Welch.
None right now.
All right, well, I do. So I understand your argument about the way in which these two statutes interact. And I have to say, I don't see how they couldn't. I mean, what does authorized by law mean if not what the CPLA allows you to do with respect to a weapon you're carrying in your car or on your person? But I have sort of I think a precursor question, which is, in Henderson, a long time ago, this court said that that it's not an element of the offense, against unlawful, whatever the language is from the statute, you know what I'm talking about. And it didn't use the word affirmative defense, but the way the opinion reads, it sort of says it's an affirmative defense. So, the defendant can come forward with evidence that he was in fact licensed, and then we can get into the details about what that really means, or he was never notified that he wasn't licensed, putting that aside for now. But we normally think of affirmative defenses as something that that a jury decides. So I don't understand why this is here in motion practice. It's not an immunity. It's not an immunity provision, right? An immunity provision would, I think, maybe in some cases at least, give somebody charged the opportunity to say to a trial court, I shouldn't have to go to a jury on this case because I shouldn't have to take that risk. But I think per Henderson, which I don't think you've asked us to overrule, and I'll put all my cards on the table, I don't think Henderson is right. When you look at other statutes, I think it is an element that the prosecutor should have to prove beyond reasonable doubt, but that's not what this court has said, and you haven't asked us to overrule it. So putting that aside, why are we here at on a motion?
I think that's a really good point. And I think in the typical case, right, that this type of motion practice would be the wrong way to handle this. So if you think about, take a case where, let's say you have a client who says, nope, never received notice. And then you have a police officer who says, just to make it really clean, I hand delivered that guy notice and I entered, it into the lien. In that situation, right, you don't have a pretrial hearing where the judge decides, okay, I think the client's telling the truth and not the police officer. I think that's right, that would be something for a jury to decide. In this case, it was unique because basically both parties agreed, at least at the trial court level, that this hinged on the 2015 revocation and whether notice was given for that revocation. And basically what the prosecutor was saying was, we're going to live or die on this lien entry. And so the way that they proceeded, they were ready to defend this on the merits. And I think certainly they could have raised the procedural point that, we shouldn't be deciding this now. This should be for the jury to decide. But they said that's not the way they chose to defend it.
Okay, so waiver is your answer. I get it. Okay, fair enough. Justice Zara.
No questions at this time. Thank you.
Justice Viviano.
I have one or two. One is you point in the CCW statute to the as provided by law language, but isn't there a second indication that the CCW statute is pointing back to the CPLA, the Licensure Act? The first provision is, persons shall not carry a pistol, concealed, etc., without a license to carry the pistol as provided by law. But then the second part of the statute says, and if you're licensed, you can't carry the pistol in a place or manner inconsistent with any restrictions upon such license. Isn't the with any restrictions upon such license a reference again to the CPLA, or would there be somewhere else that we would look for restrictions on your concealed carry license?
No, I think that's exactly right. I think right to determine what restrictions are on the license. Yeah, where else are you going to look except for the CPLA? The point that Justice McCormick raises about Henderson, my understanding is that looking back to 428 in the CPLA, that subsections 8 and 9, which I think you're focusing on, those were added, and those provisions were added to the statute, I think in 2000. I was just looking that up. But in any event, after Henderson, is that your understanding, or is that you have a different understanding? I believe that's the case, Your Honor. And so whatever impact Henderson might have had, the legislature might have tried to change that when it added these provisions, yes? I agree. I know the Chief Justice said we're focused on the law, and that we're usually supposed to be, but occasionally we do have factual curiosity. So in a very short time period, can you help me understand your client's theory in this case? In other words, even if you win legally, does your client have any chance to win on the facts? So, right, going back to kind of what I was talking about before, at the trial court level, everyone was focused on this 2015 revocation. It was only once we got to appeal that the prosecutor said, wait a minute, no, we're going to go off of the 2013 suspension. And so really, we did not, or the trial counsel did not have an opportunity or really a reason to develop a record on the 2013 suspension and then the dismissal and reinstatement of the OWI. And that's why we're asking at a minimum that we deserve a chance to litigate those issues. I don't want to go outside the record, but certainly
All right,
I think
let me cut you off, but you're asking for a remand.
correct.
Okay, thank you.
Justice Bernstein,
No questions, thank you.
Justice Clement. Did I already start with you?
With me, yeah.
You want to go again? You want to go again? Yeah. Counsel, you have some time left. If you want to reserve it, you may, or you can keep talking.
I will reserve my time for rebuttal. Thank you.
Okay, thank you very much. Mr. Melzich.
Good afternoon. May it please the Madam Chief Justice, may it please the court, Louis Meislish on behalf of plaintiff appellee people of the state of Michigan. Let me respond to a couple of things that counsel said and some of the questions that were asked. The question about Henderson, I believe there's a statute 776.20 that Henderson interpreted, which says that the burden is on the defense and that assumes that there is an available exemption. Of course, my position is that there is no exemption for lack of notice in the penal code, but there is a statute on that point. Part of the reason for the procedural posture of this case is because in the trial court, the defendant said he had qualified immunity from arrest that divested the officer of probable cause to arrest him for the CCW offense, didn't dispute that there was probable cause to arrest him of the other offenses, and asked the court to suppress evidence and dismiss the charge of CCW and leave the other charges intact. And the court then did that. I think that was a little nonsensical. But in the Court of Appeals, the defendant said that there was insufficient evidence to sustain a guilty verdict, and that's why the trial court should be affirmed. Now the defendant seems to be saying that it's more of a defense. But in any event, that is why we're here. There was a question that was asked about 750.227 paren 2, which is with regard to the language without a license to carry the pistol as provided by law. And if you read that sentence from paren 2 from the beginning, it talks about basically how a person, if they're going to carry and conceal on their own property or on land possessed by them, they don't need a CPL. So if it had simply said without a license to carry the pistol, there's a potential ambiguity in that statute, because it could be read to mean that if you are on somebody else's property, you're not trespassing if you have their okay to be on their property, and you're not in violation of the penal code if, just as they licensed you to be on their property, they've licensed you to carry a concealed pistol. So by saying as provided by law, they're saying what the Henderson court interpreted to mean. It's just a recognition that you can be licensed. Years ago, the legislature made a policy determination that carrying a concealed pistol, carrying a concealed weapon generally, but also carrying a concealed pistol is a violation of the penal code. And there's certain exemptions for that. Military members, police officers, as well as CPL licensees, people who are trained in the safety, firearm safety, and firearm laws. But where the defendant doesn't claim to be a police officer or a member of the military, the only possible exemption for him would be to be licensed. And the penal code is clear that you have to have a valid license, not an alleged belief in the validity of your license or alleged ignorance as to the invalidity of your license. And the defendant's license has been continuously invalid since 2013. And that's from page 4B of the appendix. In fact, it's the first page of the statement.
Counsel, let me interrupt you. But I appreciate the facts, but let's see what questions folks have. Okay, Justice Clement.
Thank you. Just one question. Can you explain to me what appears to be somewhat of an odd result, that a defendant who did not receive notice that their CPL was suspended or revoked, under your reading, would not be liable for a misdemeanor charge under the Firearms Act, but would be liable for a felony charge under the Penal Code?
The legislature does not want individuals who whose licenses have been suspended or revoked going around carrying around those CPLs, those permits. The crime under the penal code, by default, again, it is a crime to carry a concealed pistol unless you have an exemption, unless you have a license. But the default is that it's against the law. The legislature said, okay, if you commit that crime of commission, that's going to be a felony. As to the crime under the Firearms Act, they said that's a crime of omission, and that only attaches upon being told you have an obligation to do this. By default, you cannot carry a concealed weapon. But under the Firearms Act, you only have a duty to surrender the license when you're told you have to surrender the license. And in this case, if you look at page 15B, the defendant was told when his license was suspended, you have to surrender the license. And so the order that you're violating is the gun board's order, where they suspend your license and tell you you have an obligation under the MCLs to surrender your license. And so the legislature is allowed to define what's a felony, what's a misdemeanor, and what's a defense to a crime. And that's from this court's case law, such as People versus Carpenter, and the U.S. Supreme Court, Kansas versus Kaler. I hope that answered your question.
It did. Thank you.
Justice Kavanaugh.
No questions.
Justice Welch.
No questions.
Counsel, let me ask you the same sort of procedural questions I asked your colleague. I appreciate your pointing me to 77620. I don't think that helps me that much with my Henderson question. 77620 says if there's an exception, excuse, proviso, or exemption, it's on the defendant. That's consistent with how we think about affirmative defenses generally. But as I said before, I don't think my view of whether whether it should be an element or not is that relevant, since Henderson said it's not an element. So that is what it is. No one has asked us to reconsider Henderson, but I still don't understand why we're here on a motion. When the defendant filed a motion to dismiss this charge, why wasn't your response, there's no immunity here? That's an affirmative defense. The defendant can raise that defense at trial. And do you agree with co-counsel that you've waived any procedural argument here?
I'm not making any procedural argument per se.
No, I know but I don't understand why not. I don't understand why in the trial court you didn't say, Judge, this is thing that the defendant, believes he, wasn't notified about his suspension, but that's for the jury. That's not a reason why the charge should be dismissed before it gets to a fact finder. Why wasn't that your response? Well,
To be clear, we didn't acquiesce in the court's decision, and we didn't express satisfaction with the court's decision. So the waiver doctrine completely does not apply.
Well, no, it's not. I don't think it's acquiescence in the court's decision. It's the defendant made a motion. You responded to the motion on the merits. You didn't respond and say, this isn't a proper motion because there's no immunity provision, right?
I mean, that's correct. We didn't raise the argument of whether you need to prove whether there is a legal requirement of notice in applying in a penal code prosecution. I can see that that issue, or I should say, that argument was not preserved. But we did object to the dismissal, and the Court of Appeals precedent, and this court sometimes raises issues too that neither of the parties raise. The Court of Appeals properly determining whether the defendant had notice or lacked notice presupposes that the prosecution needs to provide notice at all. And to take this case and to reverse that decision, this court would need to conclude that the Court of Appeals clearly erred in that determination.
Yes.
And I don't think the defendant can make that showing.
Okay, thank you very much. Justice Zara?
No questions, thank you.
Justice Viviano?
Counsel, looking at subsections 8 and 9, as I understand your position, it is that they do not apply to the carrying concealed weapon offense that's in the penal code. Is that right?
They do not apply to a prosecution of the penal code. Correct. Yes, Your Honor.
And so then I'm sort of left with wondering, okay, well, how do they apply? You know, the legislature added these provisions. Usually when they do so, they intend them to have some legal effect, right? And so I guess my question is, what legal effect do the subsection 8 and subsection 9 have? If I understand your argument further, I think you're indicating that you think that they, I guess let me ask you this. Is it your position that both of them relate to the failure to surrender your license?
No. I believe subsection 8, the second sentence of section 8 relates to failure to surrender your license. Section 9, I believe, is a reference to certain crimes in the Firearms Act for carrying, not necessarily carrying and concealing, but carrying a pistol in prohibited areas, and that's 28.425O. And if I can elaborate a little bit, Your Honor, the defendant is saying that is that okay?
Well, yeah, but you're sort of getting to where I want you to get to, so I'm afraid you're going to go away, but go ahead.
Okay, well, please cut me off if I do.
Well, I think under 8, one way to read 8 is the way that you're reading it. I don't know that that's the only way, but focusing on 9, as you have, and you've indicated that I sort of agree with you. I was wondering, is there an offense for carrying a pistol in violation of the act?
Yeah, I believe that's 28.425O.
Now, the problem I have with relating it to O, which is the location restrictions, is that 9 implies that you're carrying it after your license has been suspended. And the offenses in O relate to situations where you have a valid license, but you carry a pistol in a place that you're not supposed to, like a school, etc. So it seems to me that the offenses in O don't match up with subsection 9. And then just to finish the point, I had a difficulty finding, like you, this is the only one I could find that was even close. Without O, there's no other violation in the CPLA for carrying a pistol without a license. Because I like history, we looked it up. In 1927, that prohibition that's in the penal code was actually in the licensure statute, but 4 years later, the legislature separated it and moved it into the penal code. But in any event, I guess, how do you respond to my point that O relates to people who have a valid license but take the pistol somewhere they're not supposed to, but 9 seems to relate to only people who had a license but their license was revoked?
I think, if I understand your question, Justice Bibiano, I think 9 refers to not prosecution, but arrest and the validity of arrests. And that's the language that's used in 9.
That on its own, by the way, is a way that the legislature provides immunity, right? Here, immunity from arrest, and then after that, prosecution would follow, right? So that's a way that the legislature provides immunity, is it not?
Well, in the statute I've seen, for example, in the recent enactment of the Michigan Regulation and Taxation of Marijuana Act, I think there's the words arrest, prosecution, they're used separately. So I'm not sure I agree on that point, respectfully. But to answer the question you were asking, in 9, excuse me, I think that refers to 425O because certain individuals who are members of certain professions and who have CPLs can carry in certain areas, certain otherwise off limits areas. But I think what this section is saying is that you can't arrest them for carrying in those areas if their license is invalid and they're one of those certain groups, unless they've received notice. And that's for a charge under the Firearms Act. But if I can talk about subsection 8 for a moment, subsection 8 has two sentences. And it's notable to me that the defendant is saying that you have two separate bodies of law that are in pari materia, but he's really overlooking two sentences in the Firearms Act that I think you need to read together, and that's in subsection 8. The first sentence says a subsection or revocation order or amended order issued under this section is immediately effective. And if the license is your exemption from prosecution under the penal code, as I think it clearly is, that means that the moment it's suspended or revoked, your exemption from prosecution is gone. Now, where the defendant doesn't have a due process claim here, and I think the statute should be interpreted with its plain meaning. And so the first sentence again says the order is immediately effective. So it can't be both immediately effective and have its effect contingent on something else. That would mean that the two sentences are in conflict with one another. And I don't think they're in conflict. And that's because the second sentence doesn't say criminal liability, period. It says criminally liable for violating the order. And we know what the order says. And the order is on page 15B. And so there's the defendant's interpretation of this paragraph containing two sentences. And if you follow his argument to its logical conclusion, the suspension and revocation order is immediately effective, but it's not immediately effective. It can't, that's not possible. And so I would submit that what they're doing is they're talking about two separate things. The effect of the order, and Henderson says that the as provided by law simply is a recognition that a person may be licensed to do what is otherwise prohibited, which is carry a concealed weapon. So if the suspension revocation order is immediately effective, then it's immediately effective and his exemption is gone. The second sentence is of course talking about the order, and your liability under the Firearms Act is triggered upon being given notice of your obligation to surrender the license, which the defendant had on page 15B of the appendix. And then returning again to the next paragraph, paragraph 9, the last 5 words are for carrying the pistol in violation of this act. And I think considering all those things, the language in the Firearms Act is clear that this notice provision only applies to crimes under the Firearms Act. But in addition to that, there's the language of the penal code, which provides a laundry list of exemptions, none of which are notice. And in fact, it either says license or valid license in sections 227, 231, and 231A. So between, and I cited the recent decisions of this court in Feely and Washington. And I think it's just as the Feely court observed in Justice Bernstein's opinion 5 years ago. An act that incidentally refers to the same subject is not in pari materia if its scope and aim are distinct and unconnected.
Let me finish because
let me get back to Justice Viviano. Did he answer your question? Do you have additional questions?
I just want one last point, and then I'll move on. And it's because it's the point you got to at the end, which I think is more. We've already proceeded way past this point, but is it your argument that these statutes are not to be read in pari materia? That seems so strange to me in light of the fact that 2 times in the penal code statute 750.227, it refers to the Licensure Act, not by name or citation, but certainly as provided by law. Without a license to carry the pistol as provided by law, and with any restrictions, inconsistent with any restrictions upon the license, those are references to the CPLA. Wouldn't you agree?
I think, but I would go back to what the court said in Feely and what the court said in Washington, which are incidental references, don't make them part of the same whole. The doctrine of in pari materia is to interpret words in a statute, here the penal code.
Don't both these statutes have as their purpose the regulation of the carrying of pistols, firearms?
No, well, the penal code's purpose is to define crime generally and prescribe the punishments for crime. And the Firearms Act is much narrower and is more to set up a regulatory and licensing scheme for people to obtain licenses. For example, it sets out the training requirements in 425J, the requirement that the person be trained on all laws that apply to carrying a pistol in the state, that the legislature has to prepare a compilation of.
I know, my colleagues are going to grow impatient with both of us, so I'm going to cut you off, but it
Okay.
seems to me all of the subject matter, as I mentioned already, that's what it deals with. That's why in the early days, the criminal prohibitions contained in the Licensure Act, but by moving it out, it's not because the subject matter has changed. It's just because we've decided to codify our criminal laws, a lot of them, not all certainly, but a lot of them in the same place. But with that, counsel, I'll yield to my colleagues.
Thank you. Justice Bernstein, do you have any questions?
No, thank you. But counsel, I have to say you're doing an excellent job. Like you've definitely been on the spot for a while, and I have to say you performed beautifully.
I appreciate that very much, Your Honor.
What do you mean by on the spot, Justice
You bet.
Bernstein?
Justice Viviano, you may not
I
speak
just
anymore. And Justice Bernstein, you too. Quiet down.
No, but thank you very much, counsel. I have no questions for you.
Thank you very much. Mr. Doman, you have 4 minutes and 43 seconds if you choose to use it.
Thank you, guys. Yeah, I think judging by the court's questions, I think it understands the issues here. And so just one last point. This court has held that the purpose of a statute can help the court decide between textually permissible interpretations. And in 428 subsection 8, the legislature obviously did not want CPL holders who have not received notice to be criminally liable for something. And I think at the end of the day, it really makes no sense that the legislature would protect CPL holders from misdemeanor liability, but leave them exposed to felony liability. And so we'd ask the court to reverse the Court of Appeals, reinstate the trial court's decision, or else remand for further factual development. Thank you very much.
Thank you, counsel. The case will be submitted. That concludes today's case call. We will see you next month.